Good morning and welcome to the first session of the 4 New Square Professional Liability Conference 2025. I think a lot of you know me. I'm Sian Mirchandani, KC, and along with Kelly Yu, who is one of our juniors from Chambers, I'll be taking you through some of the key aspects of the Supreme Court's decision in URS and BDW. You've seen from the title of this talk that we're focusing on the hazards and the opportunities. That's largely because we see that there are obviously opportunities for parties like the developers looking to pass on claims and some serious hazards for others, notably professionals. Many of you will be so familiar with the facts of this case, but to get everybody onto the same playing field, I'm going to do a very brief run through of the facts so that we are all together going through the rest of this talk. The case began as BDW against URS. BDW was a property developer and remains a property developer. Barratt Homes, David Wilson Homes are their brands. After the Grenfell Tower fire, BDW was undertaking cladding remediation works at Cityscape, one of its high-rise residential developments. And during those works, BDW noticed cracking in the foundation slab of one building. The investigations that it undertook that followed showed that it was at risk of structural failure. URS had provided the structural design services. BDW was prompted by this finding to undertake a wholesale review of its tower block developments, and in late 2019, it discovered design defects in 2 sets of high-rise residential building developments, and URS had been the designer in both. In 2020 to 21, BDW performed the remedial works on the development. So these are the remedial works to address the foundation issues. BDW did so despite not being the owner and despite not having been sued by any homeowners. In 2020, BDW brought a claim against URS to recover the costs of those remedial works, and that original claim was in the tort of negligence. Subsequently, the claim was amended after the BSA, the Building Safety Act 2022, came into force in June 2022. And those amendments are really why we're here. The first amendment was to include claims under the Defective Premises Act 1972, the DPA, relying on Section 135 of the Building Safety Act, the BSA, as inserted by Section 4 of the Limitation Act, as well as a contribution claim under the Civil Liability Contribution Act 1978. Now, before addressing in detail some further topics that we're going to be looking at, just want to highlight the 3 themes to bear in mind with these building-related cases. One issue that crops up again and again in the course of our talk, but also in dealing with these claims, is limitation periods. Many aspects of the decision in URS need to be considered with a view to the running of limitation periods, whether those be in negligence, contract, contribution claims, or DPA. Secondly, there are complexities and uncertainties, both in the law and as a matter of fact, surrounding the date of accrual of a cause of action. And that's a common issue in these construction claims. Now, these arise because of literally technical difficulties as a result of the latency and the undiscoverability of the defects, then the lengthy investigations that are required to uncover the original defects that you're seeking, which undoubtedly lead to finding further defects. We then have lengthy remedial works, during the course of which further defects may be found. And of course, we've got the retrospective extension of limitation under Section 135 of the BSA. So one can see how that retrospective extension could well be called upon as subsequent defects emerge during the course of the investigations. It's also important to note that the claim in URS, like so many others, arises in the aftermath of the Grenfell Tower fire tragedy. And that has public policy impacts. You will see that that is a theme that's palpable throughout the Supreme Court's decision. The topics that we're going to be focusing on are these 3: the discoverability of damage and Pirelli, which, as you all know, was not addressed in URS and BDW. Contribution claims, both of those first two topics Kelly will be dealing with, and then matters relating to the Defective Premises Act, and I will deal with those. Hopefully, we will have some time for some questions after that. So I'm going to hand over to Kelly now.
Thank you, Sian. So the first topic we wanted to discuss today relates to discovery or discoverability of a defect, and how that affects the accrual of a cause of action in tort. So just to preface this topic was originally going to be addressed by Tom Asquith, who has valiantly stepped up to do a different talk. So all credit for this section goes to Tom, but all mistakes are mine alone. So in URS and BDW, one of the issues considered by the Supreme Court was the accrual of a cause of action in tort for a defective building. The central question is this: is damage suffered when a building is made defective, or is it when a claimant discovers the building is defective? The court in URS made some interesting observations, but chose not to decide the issue. To many professional negligence lawyers, the question might appear odd, since the answer seems obvious. Discoverability is irrelevant to the running of time. A cause of action in tort is complete upon damage, and it's for that reason that there are various interesting authorities about when damage is in fact suffered. Issues of knowledge only come into play. It might be said when looking at Section 14A of the Limitation Act, which provides that 3-year extension period after the relevant damage is known to the potential claimant. However, in terms of a potential development of the law, the Supreme Court in URS appears to indicate that there might be a role for the concept of discoverability in relation to Section 2 of the Limitation Act. And to understand why this is, it's necessary to review some of the older cases. Thank you. And the first case to consider is Pirelli itself. So this case involved claimants who had engaged the defendant firm of consulting engineers to advise on and design part of their factory premises, including a chimney. Works were carried out in 1969, and by 1970, cracks had appeared. The claimants did not discover the damage until November of 1977, and said they could not with reasonable diligence have discovered it before October 1972. In October 1978, the claimants brought a claim for negligence in relation to the design of the chimney. So in other words, the claimants had brought the claim around 8 or 9 years after the works had been carried out and the cracks had appeared, but within 6 years of when they said the damage was discoverable with reasonable diligence. The judge at first instance held that the cause of action accrued when the damage was discovered or ought with reasonable diligence to have been discovered. And that was based on the Court of Appeals case in Sparham-Souter. The judge considered that the cause of action accrued when the plaintiff and not the building suffered damage. And the plaintiff only suffered damage when he discovered, or ought with reasonable diligence to have discovered, damage to the building. So the Court of Appeal dismissed the defendant's appeal. However, the House of Lords allowed the appeal. The House of Lords held that the date of accrual of the cause of action was the date when the damage came into existence, not the date when the damage was discovered, or should with reasonable diligence have been discovered. Since the cracks had appeared by 1970 and the claim was issued in 1978, it was statute barred. Lord Fraser, giving the judgment of the House of Lords, relied on the personal injury case of Cartledge and E. Jopling, and it had been held in that case that time ran from the time that a person was injured, whether aware of the injury or not, so relying on that personal injury example. Lord Fraser explained that the core reasoning of the courts below was that until the owner had discovered the defective state of the property, he could resell it at a full price, and if he did so, would suffer no damage. And in this way, the position was different to the personal injury case of Cartledge. While someone could get rid of their house before suffering damage, they couldn't get rid of their own body. Lord Fraser couldn't agree with that reasoning. He saw parallels between the victim of bodily damage and the person whose house had been damaged. He said, just as the owner of the house may sell the house before damage is discovered and suffer no financial loss, so the man with the injured body may die of pneumoconiosis before pneumoconiosis becomes apparent and may also suffer no financial loss. He held that time had started to run when the cracks occurred at the top of the chimney, no later than April 1970, even though that was before the date of discoverability, and said that the law is now so firmly established that only Parliament could alter it. Lord Scarman agreed with Lord Fraser, but said that the result produced by the law was harsh and absurd. He noted that Parliament was working on a statute to address latent damage, and that fortunately reform could now be expected. Now, of course, we now know that the Latent Damage Act of 1986 made provisions through Section 14A of the Limitation Act to give claimants an additional limitation period, which would be 3 years from the date of discovering or being able to discover the damage. Now, the next case to consider is Invercargill, which is a Privy Council case hearing an appeal from the courts of New Zealand. So in 1972, a firm of builders had built a house for the claimant. During its construction, a building inspector employed by the city council carried out a number of inspections. That building inspector then approved the foundations. In 1974, cracks began to appear in the building, and in 1989, another builder told the claimant that the foundations were defective. In 1990, the claimant brought a claim. So this is only 1 year after the claimant is told the foundations are defective, but around 18 years after the house was built. So the judge applied a test of discoverability for limitation purposes. He held that a reasonably prudent homeowner would not have suspected that the foundations were defective until the time when the second builder had visited and said that the foundations were defective. The Privy Council upheld the decision of the judge and chose not to follow Pirelli, holding that economic loss only occurred when the market value had been diminished by reason of the defective foundations being discovered. Accordingly, the claim had been brought in time. The Privy Council emphasized that their views on the limitation point were confined to the problem created by latent defects in buildings. They abstained from considering whether reasonable discoverability should be of more general relevance in the law of tort. Further, they noted that it was not for them to decide whether Pirelli should still be good law in England. However, it was clear to them that it was not good law in New Zealand. So that's an early sign of Pirelli not being endorsed by the court. And the final case to consider is a more recent Court of Appeal case, Abbott and Will Gannon. This case involved a claimant company who retained the defendant as structural and civil engineers. In May of 1995, the defendant designed works relating to a large bay window in a hotel. The window was completed by the builder in March of 1997 as designed, and in late 1999, the claimant noticed that the lintel over the bay window had moved and cracked the surrounding structure. So this is sort of a case not of defective foundations, but where a window is cracking the surrounding structure. In September of 2003, the claimant issued proceedings against the defendant in respect of the defects which had become apparent in 1999. So again, this is over 6 years after the window has been built, but 4 years after the defects are apparent. The Court of Appeal held that the cause of action arose when physical damage had occurred. So in this case, the window had caused physical damage to the surrounding structure only in 1999. The fact that the defects in construction which caused that damage to occur had been present earlier was irrelevant, even if it had resulted in economic damage. Even if the cause of action had arisen when the claimant suffered economic loss, the claim would still not have been statute barred because the building would have only depreciated once the cracking had appeared. This case was, of course, issued and decided well after the Latent Damage Act, but the 3-year extension under Section 14A did not assist the claimant because 4 years had elapsed since noticing the problems and the claim being issued. The court held that it was not clear what the state of the law was in England, but found itself bound by the indistinguishable facts of Pirelli. If, in the alternative, the court was not bound by Pirelli, it held that the claimants did not suffer economic loss in March 1997, but only when it manifested itself in some way which affected the value of the building, either measured by the cost of repairs or depreciation in market value. In this way, the court accepted Lord Lloyd's analysis in Invercargill. So while the Court of Appeal said it was bound by Pirelli, this alternative ratio appears to effectively be a rejection of Pirelli, because it's linking damage with that damage being manifest or discoverable. Lord Justice Tuckey said that this was the common case where the occurrence of the loss and its discovery coincide. As a result, the court found it did not have to grapple with the difficult problem of whether there was more than one cause of action for limitation purposes. And now finally, turning back to URS and BDW. Now, the reason, of course, that the Supreme Court in URS and BDW sat as an extended panel of 7 judges was because of the possibility that the court might be asked to overrule Pirelli. However, the Supreme Court ultimately held that it didn't need to decide whether to overrule Pirelli, and this was because URS had claimed that BDW should not be able to recover for the cost of remedial works completed by BDW because those remedial works were done voluntarily and thus were irrecoverable. The Supreme Court had rejected URS's argument, holding that there was no voluntariness principle, and that in any event, BDW's actions were not fully voluntary, since there was potential for further personal injury claims against BDW or reputational damage if they didn't remedy the defects. If URS had succeeded on that voluntariness argument, then it would have been relevant to consider Pirelli. However, in the event, that issue fell away. So the Supreme Court confined itself to making just 3 points about Pirelli. The first point was that Pirelli was decided on the false premise that cracks in a building constitute physical damage. In fact, as we now know, the position is that cracks in a building caused by defective foundations are a manifestation of pure economic loss. The decision of the House of Lords in Murphy and Brentwood, overruling Ans and Merton, makes clear that cracks in a building are just a physical manifestation of those inherent structural defects, and loss relating to structural defects is pure economic loss. The second point was that this false premise does not necessarily mean that Pirelli was wrong about when the cause of action in negligence accrues. In other words, Pirelli might be right in that the accrual of a cause of action in tort occurs when the relevant damage is suffered, rather than when the damage is discovered or could reasonably have been discovered. The third point was that in the context of pure economic loss, there are strong arguments of principle for accepting there can only be an actual loss once the pure economic loss has been discovered or could reasonably have been discovered. And in making that comment, the Supreme Court referenced the reasoning of cases in Canada, Australia, and the Privy Council's decision in Invercargill. However, the court also noted that Parliament's intervention through Section 14A and Section 14B of the Limitation Act needed to be considered, since enacting those provisions, Parliament had assumed the date of discoverability was different from the date of the accrual of the cause of action. So in other words, and without deciding the issue, the Supreme Court appears to indicate that Pirelli is right that the date of accrual of the cause of action is the date of the relevant damage being suffered, but in cases of pure economic loss, Pirelli might be wrong in that discoverability is relevant to when damage is suffered. And that accords to common sense. As acknowledged in Pirelli itself, the market value of a defective building is unlikely to be affected unless the defects are discovered or discoverable. In light of the Supreme Court saying that the point must await a case in which what is said will be ratio, and in light of the Court of Appeal's decision in Abbott, it appears that a date of discoverability argument may well be worth running for claimants. And that brings us to the end of our discussion on Pirelli, and on to our next substantive topic for discussion, namely contribution claims. Now, after considering Pirelli, which the Supreme Court didn't end up deciding in URS, we now turn to an issue which the Supreme Court did end up deciding. So as Sian has already summarized, URS had defectively designed developments for BDW. One of the claims brought was a contribution claim to recover the cost of remedial works. And notably, BDW had conducted those remedial works without any third party having ever asserted a claim against BDW. And nonetheless, BDW sought to recover a contribution from URS. So in URS, the Supreme Court had to decide when the right to recover contribution arises. It was presented with 2 conflicting positions. BDW sought to claim that the right to recover contribution arises as soon as damage is suffered by the prospective claimant for which two parties are liable. URS argued that the right to recover contribution does not arise unless and until the existence and amount of BDW's liability had been ascertained by judgment, admission, or settlement. Lord Leggett held that the true position lay in between. So I've set out the full quotation on the slide, but I won't read that out in full. Just to summarize that passage, the first uncontroversial point made by Lord Leggett here is that the right of BDW, or D1, to recover a contribution from URS, or D2, arises when damage has been suffered by a claimant or a potential claimant for which both D1 and D2 are liable. And the court here is referring to the familiar requirement in Section 1 of the Contribution Act that a contribution can be recovered from any other person liable in respect of the same damage. The second and the more important requirement is that the right to recover contribution arises where D1 has paid or been ordered or agreed to pay compensation in respect of the damage to the claimant. There's no requirement that before an action can be brought, the amount which D1 is liable to pay has been established by judgment, an admission, or a settlement agreement. It was also held that a payment in kind would also be sufficient. So just breaking that down, the court in URS is saying that the right to recover a contribution arises where D1 pays the claimant, D1 is ordered to pay the claimant, so for example in a judgment or court order, or D1 has agreed to pay the claimant. A payment in kind, like remedial works, is also sufficient. The key point here is that the payment by D1 to the claimant is enough. The payment doesn't need to be underpinned by a court judgment or a settlement agreement. So you'll all be familiar with the 2-year limitation period for contribution claims set out in Section 10 of the Limitation Act, 1980. URS and BDW, of course, also gave guidance on the time when limitation starts to run. Section 10.3 of the Limitation Act says that if D1 is held liable in respect of damage which is the subject of the contribution claim, limitation begins to run at the date of judgment or an arbitration award against D1. Lord Leggett tells us in URS that under Section 10.4, time will also start running if D1 simply pays the claimant. Section 10.4 of the Limitation Act says that where there is no judgment or arbitration award against D1, if D1 makes or agrees to make any payment, time will start running when the amount is paid or agreed to be paid. So in other words, we should be astute as lawyers here to think about when our clients make payments of whatever kind. URS is of course an example of a payment being made in kind. BDW conducted remedial works. And this is a trap for the unwary, because in the construction context, parties may well do work for a former client and inadvertently start time running for contribution purposes without any judgment or settlement agreement having been entered into. Now, another point to note is that under Section 10.4, it expressly states that this is whether D1 admits any liability in respect of damage or not. In other words, a defendant carrying out remedial works, even if on a non-admission of liability, could inadvertently set the 2-year timer running. Now, it'll be obvious here that this raises a whole host of potential issues about what might set the clock running for limitation purposes. Interim remedial works, especially on a high-value project, could take a number of years. So does limitation start running on day 1 of the remedial works, or does limitation start running when the remedial works come to an end? Taking just a first principles approach to the decision in URS, one important thing to bear in mind is that a contribution is a proportion of another amount of money. So Lord Leggett says that it's not possible for a court to make an order for contribution in favor of D1 against D2 unless and until an amount of money can be identified of which D2 may be ordered to pay a proportion. So in other words, without knowing how big the pie is, it's impossible to cut a slice. URS also says that in order to be the subject of a contribution claim, a payment in kind must be capable of valuation in monetary terms. So unless and until an amount of money can be identified from which a contribution can be taken, no claim can be brought by D1 and limitations should not start running. Now, there is, of course, a limit to how much needs to be ascertained before D1 can bring a contribution claim against D2. Lord Leggett was clear that there was no need to wait for BDW's total liability to the homeowners to be ascertained before a contribution claim could be brought. So, for example, if BDW's remedial works would only partially cure the defects of the development, or if BDW was subject to a further claim by homeowners, BDW would not have discharged theirs and URS's shared liability to the homeowners, and both instances could give rise to a second contribution claim. So again, this is a trap for the unwary. From the perspective of a party defending a contribution claim, there has to be an awareness of the possibility of further claims down the line, arising out of the same subject matter. If D1 has only partially discharged the shared liability of D1 and D2, D2 might face another contribution claim down the line when further remedial works or further payments are agreed. So I just wanted to round off this section about contribution claims by thinking about the procedural mechanisms by which contribution claims are brought. So CPR 20.6 allows a defendant to bring a contribution claim against an existing party, and CPR 20.7 allows a defendant to bring a contribution claim against a third party. Both can be done without the court's permission if done at the same time as the defense. URS and BDW recognizes that CPR 20.6 and 20.7 provide a mechanism by which D1 can bring a contribution claim before limitation has even started running. And they can do so by bringing the contribution claim against D2 in the same proceedings as the claimant's main claim against D1. Lord Leggett sets out the court's perspective that having the contribution claim brought in the same proceedings as the main claim is usually more efficient and avoids the risk of inconsistent decisions. However, parties often take a different view. Conventional wisdom on contribution claims is that where a case is being defended, it's often desirable to delay the bringing of contribution claims and make them after the main proceedings have come to an end. This allows the defendant to focus on fighting the claim rather than blaming another defendant, and potentially reduce the risk of the cost, or reduce the cost of the litigation by minimizing the parties before the court, and also give the defendant a chance to settle the claim before deciding whether it's worthwhile to seek a contribution at all. However, parties must bear in mind that if they do choose to defer the contribution claim until a later date, they need to be mindful of the limitation period. Parties should not simply think that they have 2 years from the date of any award or settlement. If the defendant has made a payment or a payment in kind earlier, then time might begin to run from an earlier date. And although we have, in the context of contribution claims, been talking about a 2-year limitation period, those bringing claims under the DPA may have considerably more time. And that, of course, brings us to the next topic for discussion, claims under the DPA, for which I'll now hand over to Sian.
Thanks very much, Kelly. Before we get back again to the issue of limitation, which is frankly ubiquitous in this area of law now, I want to highlight there's another talk happening. There's another talk happening in this conference which touches on Larnell and whether it lives on or not. Now, Larnell is concerned with what happens when a party becomes insolvent. Just highlighting that for you. It's important to consider to whom duties will actually be owed under the DPA. Section 1 of the DPA provides that a duty will be owed in 2 circumstances. A, if the dwelling is provided to the order of any person to that person, and B, without prejudice to the above, to every person who acquires an interest, whether legal or equitable, in that dwelling. In URS against BDW, BDW argued that URS owed them a duty under Section 1 of the DPA. URS asserted that no such duty was owed. URS argued that under Section 1.4 of the DPA, and you can see it there on the slide, a person who in the course of business, which consists of or includes providing or arranging for the provision of dwellings or installations in dwellings, or in the exercise of a power of making such provision or arrangements conferred by or by virtue of any enactment, arranges for another to take on work for or in connection with the provision of a dwelling, shall be treated for the purposes of this section as included among the persons who have taken on the work. So BDW also owed a duty under the DPA, since BDW had arranged for others to take on work in connection with the provision of the residential properties. And URS asserted that it was inconsistent and absurd for BDW to both owe and be owed duties under the same statutory provision. Now, in addition, BDW was, of course, a commercial developer, and it was URS's position that the purpose of the DPA was to provide consumer protection, not intended to restrict any freedom of contract between commercial parties who should be able to decide whether they wish to be liable or not. Now, unsurprisingly, and again, there's that public policy theme behind all of this, the Supreme Court decided against URS and held that URS did owe a Section 1 duty under the DPA to BDW. And they did so by confirming that URS had carried out relevant work to the order of BDW, and thus under Section 11A owed a duty to BDW. The court found no difficulty in the fact that BDW as a developer both owed a duty under Section 1 and could be owed a duty under Section 1. And as to the issue about consumer protection, the court held that a wider interpretation of the DPA was more likely to better serve the safety of dwellings and to protect consumers, i.e., if the developers were also owed the relevant duty by the professionals involved in construction and designing the buildings, then developers could then play a part in any claims for redressing building defects. In addition, at Section 141, the court expressly confirmed that the language of Section 11A does not require any proprietary interest in the land, since it merely requires that the dwelling be provided to the order of that person. It follows that the language of Section 11A also covered the standard situation, where the person ordering the work also has a proprietary interest in the land and the new dwelling. For example, where the developer becomes the first owner of the land with the dwelling. This was the case for BDW. They were the first owners of the land before selling their proprietary interest to third-party management companies. And of course, that is the usual position now for these high-rise residential apartment buildings. Although BDW did originally have a proprietary interest in the developments, there will be commercial developers who may not have had such a proprietary interest. After the land is sold, the Section 11B duty would then be owed to all those who subsequently acquire a proprietary interest in the building. So just pausing for a moment to consider, the focus on that scope of liability under Section 1 of the DPA will become very, very significant. The URS raised a further argument here, which was given particularly short shrift by the Supreme Court. URS suggested that the type of losses envisaged under Section 1 of the DPA are those arising as a result of the ownership of a dwelling which is unfit for habitation and does not encompass the cost of remedial works by a developer remedying defects caused by the negligence of a contractor. However, once you accept that Section 11A doesn't require proprietary interest and also covers and contemplates claims by developers against contractors, there was no question that a DPA claim could include the cost of remedial works that had been completed by a developer. So we have the prospect of a very wide-ranging scope of liability, which can be levied against professionals and which carries with it up to a 30-year limitation period. So where do we go to get some kind of limitations of liability? This is an area of particular concern again. Duties and the resulting liabilities under this Act are non-excludable by the effect of Section 6.3. Any term of an agreement which purports to exclude or restrict or has the effect of excluding or restricting the operation of any of the provisions of this Act or any liability arising by virtue of any such provision shall be void. That is of particular concern for any commercial parties who, when contracting with each other, also cannot exclude the effect of this Act. And Section 63 was recently considered by the High Court by Mrs. Justice Jefford in the case of Vanker and Marbank. And that was in the context of net contribution clauses, which we all know as a common clause that appears in professional indemnity insurance. It's particularly common in their appointments that architects and engineers would have this clause in place. And Vanker is a case that brings us back to the previous discussion by Kelly about contribution claims. So net contribution clauses are relied upon by defendants to limit their liability at the outset without needing to bring a contribution claim against another defendant. And so in so doing, it avoids the difficulties of those claims, so the costs and the difficulties and the tasks that can arise and affect contribution claims. In Vanker, the architect attempted to rely upon Clause 7.3 of the RIBA Standard Terms and Conditions for the Architect's Appointment, version 2010. And that limited the liability of the architect to that which is, quote, just and equitable for the architect to pay, having regard to the extent of the architect's responsibility for the loss and or damage in question. Now, those terms are clearly intended and do closely mirror the language of the Contribution Act. But as set out in the court's judgment in Vanker and Marbank, the purpose of Clause 7.3 is to achieve the same result as would be achieved under the Contribution Act via a contribution claim. It sets out to achieve that result irrespective of whether the employer also sues the contractor or any other party, and irrespective of whether or not there are any contribution proceedings. But the operation of the net contribution clause was to limit the liability of the architect, which would otherwise have been the whole of the recoverable damages. If we are in the realms of a claim involving DPA, Section 6.3 means that that net contribution clause is void and can't be relied upon by the architect in respect of the DPA claim. So specifically, when a DPA claim is pursued, parties should note that the net contribution clause can't be relied upon. A contribution claim will need to be pursued in any event, and all of the considerations that Kelly has just discussed will be becoming relevant. For example, that you may have more than one contribution claim. Now, I'm just going to look at the limitation position, returning to the issue of limitation. You will be familiar by now with the wording of Section 135 of the Building Safety Act 2022. It extends the limitation period of Section 1 of the DPA for 15 years proactively and 30 years retrospectively. And of course, the original limitation period was just 6 years. I've highlighted it in here. You can see the 15 years and the 30 years provisions at subsections 1 and 4. What I've highlighted here is the wording of by virtue of, because this, I think, is the truly startling effect of URS and BDW. The Supreme Court held in URS at paragraph 125 that the 30-year limitation period set out in that statute applied not only to claims brought under Section 1 of the DPA, but also claims which are dependent on the limitation period in Section 1 of the DPA, but are not actions brought under that section. Now, that effectively opens up all the other claims that are being run in parallel. Now, this conclusion was reached by the Supreme Court because the statutory wording, if I go back to that slide, indicates that the section applies to accrued claims which are brought by virtue of Section 1 of the DPA, not claims brought under Section 1 of the DPA. In other words, and applying that to the facts of URS and BDW, at the time that BDW carried out the remedial works on the structurally defective developments, and they did that in 2020 and 2021, any DPA claims by the owners or occupiers of those developments would have been time barred, time having run out by about 2014. However, after Section 135 came into force, those potential DPA claims by the homeowners or the occupiers would not have been statute barred, because those claims would now have a limitation period ending in 2038. So as a result, for the purposes of the BDW's negligence claim and their contribution claim, it would be relevant that the potential DPA claims by the homeowners or occupiers would not be statute barred because of the effect of Section 135. The Supreme Court considered, and this was their reasoning for giving this wider interpretation to Section 135, that they wanted to prevent two contradictory but parallel universes, one for the direct claim by homeowners against developers, and another for the onward claims by the developer against the designer and the contractor responsible for the defects. They said it would be contrary to the purpose and policy of the DPA to limit any such onward claims that the developer might make against the contractor and designer directly responsible for the defect, even if through a negligence claim or a contribution claim. It would also be contrary to public policy to penalise good developers, such as BDW, who were proactive in investigating and remedying building safety defects. Clear public policy in action there. This, of course, has a significant impact on the historic liability for any defects which render a dwelling unfit for habitation. And that, of course, is the main impact for all designing professionals and their professional indemnity insurers. So this rewriting of history, and does it have any limits? Well, there are some. We've already mentioned that in Section 135, it made it possible for BDW to bring claims in contribution and in negligence where the fact of the extension of limitation for potential DPA claims by homeowners would be relevant. But Lord Leggett, giving his concurring judgment at paragraph 304, expressly left open the relevance of issues of causation, mitigation, and remoteness. And he stated, Section 135 of the BSA makes it possible for BDW to bring claims in these proceedings against URS for damages for breach of a duty owed to BDW under Section 1 of the DPA and for contribution. But in relation to its claim for damages in the tort of negligence, which BDW had already begun before the BSA came into force, and the DPA claim, Section 135 does not retrospectively affect the answer to the questions of causation, mitigation, and remoteness, which determine whether BDW can recover compensation from URS for the cost of the remedial work carried out before the section came into force. In other words, it's still potentially possible for a contractor like URS, or rather an engineer like URS, to argue that the cost of BDW's remedial works were unreasonably incurred since they were undertaken prior to the effective date of Section 135 of the Building Safety Act. But it really remains to be seen how that very unattractive argument is going to be received by a court, given what we've clearly heard is the wider public policy approach to such claims. There are other limits to the scope and the rewriting of history, and that's via the express exceptions to the applications of Section 135 provided by subsection 5 and 6. The first of which is if the application of this extended limitation period would involve a breach of the defendant's rights under the convention, i.e. the European Convention on Human Rights, and in this country that now means the Human Rights Act, 1998. Now that appears to be mainly via the Article 6 right to a fair trial, which would be impacted upon by, in that period of time, 30 years, there would be a loss due to lost evidence, diminished recollections, or witnesses' demise or their debility. The other limitation is if a claim was brought and settled or decided before the BSA came into force on the 28th of June 2022. One final point, I'll deal with it very quickly so we do have some questions. Section 135 extended time under the DPA, but it also extended time for claims under Section 38 of the Building Act 1984. And I am quite sure that none of you have dealt with a claim under Section 38 of the Building Act 1984, for the simple reason that section is still not in force. Why it's not in force beats me, and if anybody's got any insight into that, I would be very grateful to hear it. Because we now have an extended limitation period to a section of an act which was put into place 40 years ago and has never been brought into force. I keep thinking any day now they're going to realise and they're going to bring out something which tells us that Section 38 is finally there. Because it does seem to be the most applicable remedy that we've all been missing. Thank you very much for your patience and listening to us this morning. We've got a very short period of time for some questions, if anybody has any. And then we have a breakout room to the left, as well as the one upstairs. Yeah, open to questions. Well, thank you for your attention. And as I say, we've got a breakout room down here if you fancy a quick coffee. I'm not sure what time does the next talk start? 10:45. Okay, so you've got a few minutes to move around.